Every week, powerful interests try to write or rewrite the rules in favor of those with power and money. Today, you will meet lawyer Geoff Wells, who is on the cutting edge of those who refuse to let that happen. Hello, everyone. I'm Neville Johnson. It is This Week in Law, where justice meets real people, and my guest today is lawyer, leader extraordinaire, Geoff Wells. Geoff, thanks for coming. You are the immediate past president of CAOC. What is that?
So CAOC is a statewide Consumer Attorneys of California group. We have approximately 4,000 members, all the way from San Diego up to Redding.
And you have been very involved in, there's an initiative that certain parties are trying to put on the ballot, the Uber initiative. What is it?
So the Uber initiative is an attempt by big tech to try and take over really the ability of a consumer to be able to hire the doctor of their choice. They want to rig the system so that people can't get quality lawyers to be able to represent them, and they made a very misleading initiative, making it seem like it's a consumer initiative when in fact it's very anti-consumer.
Well, what are the problems with it?
Well, the biggest problem with it is it does not allow a quality lawyer to be able to go out and help provide justice for their clients. They can't get a doctor on a lien. There'll be no money for expenses, expert witnesses, accident reconstruction, biomechanics, all of those things that will basically take that whole ability out of the system.
What does it do? It means the lawyer's not going to get reimbursed?
That's right. So they're misleading. They say the language of the initiative is, it's the client gets 75% and whatever's left over goes to the doctors and the lawyers. But in reality, when you have costs, when you have medical liens, when you have someone that maybe doesn't have health insurance, cannot go see a doctor for months and months at a time, it prevents them from being able to get quality medical care.
All right, so two things it's going to do. One, it wants to reduce the split, which is anywhere 60-40 or 70 or 2/3, 1/3, right?
That's right.
And they're going to take the costs out of the lawyer's share?
That's right. That's right.
So that could mean that the lawyer
gets nothing. Yeah. And, we have this contingency fee system. The lawyers on our side, we don't charge by the hour. We invest our own money in the case. We may work on that case for 3, 4, 5 years now. And in order to do that, you have to be able to have a system set up so that you can actually get reimbursed.
In fact, virtually every single personal injury case is contingency, isn't it?
Yes. And that's on our side. Of course, Uber's not doing anything about limiting the fees on the other side for the insurance companies and the defense.
Why is Uber doing this?
Well, I think Uber wants to make a big grab. They want to use the billboard lawyers, quote unquote billboard lawyers, in order to make it look like all the lawyers are sort of sleazy. And in reality, many of those billboard lawyers, what they do is they go out after they get a case, they refer the case to a quality lawyer. So it makes it seem like they're not ethical, when in fact they are trying to do a good job for their clients.
Let's talk about the costs of doing a personal injury case. How much can it run?
If you have a products liability case, like our firm does auto products liability cases where you might have a defective fuel tank, a defective airbag, some type of a product defect on that case could cost over $1 million. You have to do crash testing, you have to do biomechanics, and those types of things are very expensive. And it requires the lawyer to advance all those costs on the case. And of course, if we lose the case, we eat those costs.
And on top of that, you've got your overhead.
Yes. You got a staff and you got paralegals. You have experts, investigators. Sometimes you have to store the defective product in a quality storage facility where it can meet the chain of command for evidence. So all of those things, are expensive.
This is reminiscent of the late 70s with the medical malpractice restrictions. What happened there, and was there finally some equanimity that occurred?
Right. So what you're referring to is MICRA, what we call MICRA, the Medical Insurance Compensation Reform Act of 1975. And what that was a limit on the amount of damages that a person could get in a malpractice case. And at the time, Jerry Brown one was the governor, and he was threatened with all the doctors claiming they were going to leave the state if we didn't enact this legislation. Most lawyers thought that it wouldn't be held constitutional. It went up to the Supreme Court. It was held constitutional. And as a
They
result,
said you couldn't get more than $250,000 in emotional distress damages,
that's right.
which was not a unreasonable. Well, it wasn't. That was 50 years ago.
That's right, 50 years ago.
250 is a
Yeah.
lot different now.
Yeah, and that law was in place for 39 years. It took that long to be able to overturn it. Now there's been an adjustment. Really what we wanted was an adjustment for the cost of living. If you think about what a house cost in 1975 versus what it is now in 2026, it's a pretty clear situation.
So the results of Micro were that a lot of people never got justice. Isn't that right? They never could get a lawyer.
Yeah, and the really amazing thing about that, I represented some of those cases where we had senators and assembly people, and even we represented a United States senator's daughter whose baby died, and they could not believe that in California that they were limited to $250,000 for the death of their child. And out of that 250, they had to pay the lawyers some of the fees on that. You'd have to hire 2 or 3 medical experts on the case. At the end of the day, they were left with nothing but a feeling that justice was not served in those cases.
You mentioned lawyer advertising. Talk to us about that.
Right. So, we do have a First Amendment right in our country. And the lawyer advertising really became, it started out slowly in the 1980s and 90s, but now with the advent of social media and all the things that go on now, it's exploded and it's become a business. And so some people have a problem with the business, but we all feel like that it needs to be, curtailed a little bit. There's a little too much. You drive down the freeway, there's too many billboards, there's too many ads. And we need to curl that back a little bit, and we need to do a better job, I think, policing ourselves, Neville.
Well, wasn't there just an amendment or a law passed relating to whether you could go after a lawyer for is effectively false advertising?
Yeah, so I worked on that bill. That is Assembly Bill 931 with the Senate or the Assembly Judiciary Chair named Ash Kalra, and he did a fantastic job, and it was a first step, Neville. We had so many complaints from our members about misleading advertising, pay to play, your number one law firm in California, and when it was just you go and pay a fee and you would get that up there on your billboard or on your advertising. We changed that now to it's a merit-based situation where if you're ranked as a top firm, it's got to be based on merit as opposed to you just, paying a fee.
Tom Girardi was a prominent lawyer who was subsequently convicted of fraud and embezzlement, effectively, of his clients. What effect has his downfall had on lawyers?
Yeah.
And the public perception?
Yeah, it's had an enormous effect. And the effect was both, that was part of the Assembly bill too. We also had a Senate bill 37, that was done by the Senate Judiciary Chair in California, Tom Umberg. And what he said is we cannot ever have a situation again where we have a lawyer that's getting 10, 15, $20 million on this litigation funding situation and then not paying their clients at the end of the case. It's just unacceptable. And there was a lot of complaints to the state bar on that. And, they dropped the ball is what happened. So we went through with the Senate and helped police ourselves. And I think that's the first start as well. That bill talks about, doing things the right way, reporting, getting the money out to the client quickly, and hopefully we will not have another situation like the Girardi situation.
So what do you think the public perception is of lawyers these days in California?
Yeah. The public perception of lawyers isn't great, but I will tell you this, when people need a lawyer, when they're a child or a family member's been injured or killed, people recognize the importance of having an advocate for them, and their perception changes immediately once they become a client. So as far as that is concerned, I think, people appreciate the fact that somebody's out there fighting for them in justice.
Let's go back to Uber for just a second,
Sure.
which is that Uber wants this law passed because why? There are so many different sexual assault cases being brought against them. Is that it?
It's more complicated than that. There's two prongs going on. One is they have this dirty little secret about the sexual assaults going on. The campaign of almost every 8 minutes, which was based on a New York Times article of a sexual assault in an Uber, is something they did not want the public to know. So we're letting the public know about that. That's number one. But number two, they want to rig the system also, not just for cars, by the way, Neville. It's for, a bus accident, a motorcycle accident, a trucking accident. It's a broad swath of things they're trying to basically rig the system so people cannot get justice.
Is it not, and you indicated it's not just Uber, it's also what, big tech and insurance companies?
Oh, yeah. And right now, the insurance lobby has not gotten involved in this initiative. They recognize that it is not good for the consumer, I believe. But right now, big tech, they have so much money. They have, billions of dollars. They can go out and basically try and rig the system that they want to do. And I just don't think the voters in California are going to stand for that. That's why we have to get the information out to the consumer.
Oh, you've had some interesting cases in your life. I know one of them was the Santa Monica food case. What was that?
So the Santa Monica Farmers Market case was probably one of my cases that I worked on that I'll remember my whole career. And that was an 86-year-old gentleman that drove his car. He went to the post office. He was planning to take a right turn. He got confused. He thought he hit the brake and he hit the gas, and he went into the Santa Monica Farmers Market with over 6,000 people out on the street. And he went for over 1,000 yards thinking that he was pumping his brake, but in fact pumping his gas. 13 people died. 63 people were injured. There were kids. There was a grandmother with her granddaughter in a stroller that was killed in front of the mother. I mean, it's just horrific. It was one of those cases. It looked like almost like a terrorist explosion.
And
we worked on that case for 5 years. What we did was, in discovery, we found out that the city of Santa Monica, rather than put barriers on the road to protect the people in the market, they put 2 plastic sawhorses up at the end of the street. And of course, that's like a knife going through butter when you have a car. And really all they needed to do was take the cars that were the farmers' cars on the ends of the street, and instead of having them run parallel with the street, they could have turned them perpendicular on the street. That would have blocked this accident from happening. There was a variety of other traffic engineering things that could have been done that, have, by the way, have now been done. But a lot of these farmers markets, people don't recognize the danger of putting people out on the street for a farmers market. You're not thinking about traffic and you're not thinking about barriers. And so we brought that case. We got all those cases settled. There was 2 left after all of those that went to trial. We started the trial and it was settled during voir dire.
which is questioning the
The jurors, yeah.
All right, and another case you had was a 5-year-old girl in San Bernardino. Tell us about that.
Yeah, so probably one of the most difficult, heartbreaking cases I've ever worked on in my 40-year career was a 5-year-old girl. She was going to kindergarten. Her mom would drop her off at grandma's house in order to walk her across the street to the bus stop because mom was opening as a manager at a Subway. And that particular day, grandma also had to leave early, so she went to the neighbor's house and said, hey, you have your daughter. Can you bring my granddaughter with you, take her over to the bus stop? And the bus stop was near a traffic signal crosswalk, but nobody used it. Everyone jaywalked across the street and then went right to the bus stop. So as this little girl's with the neighbor, so she got her daughter in one hand and this little girl on the other hand, the girl sees the bus and says, there's my bus, and she darts out. And unknowns to her, a car is coming the other way, 38 miles per hour, Neville, no chance to really stop. The girl is thrown over 200 feet. She has a fractured skull. She suffered over 200 seizures in the next 48 hours, profoundly brain damaged. And so, we look at that case and you go, what's the responsibility here? And the driver of the car didn't have time to stop. The bus is on the other side of the street. What we found out in discovery was that the jaywalking to the bus stop had gone on for months before this accident, and they had a policy in place that if you see someone doing something dangerous, like the parents jaywalking to the bus stop, you have to cite them immediately, and if they do it again, you remove their bus privileges. That's how you prevent this from happening. So in that particular case, the bus driver basically lied on the stand and said, I never saw the kids. And I asked all the mothers, well, when you would cross the street with your child, where was the bus? She said, it was at the bus stop. I said, so right in front of the bus driver? Yes. Not only in the morning, but also in the afternoon on the drop off, they would do the same thing. So anyway, that went on to be a $38 million, $36 million verdict
And
for this girl that needed unbelievable care, and she's still alive.
liability was placed on the bus company.
Yeah, it was a private bus company. That's right.
They had insurance.
They had a ton of insurance.
And what about the city?
So the city got out on the summary judgment, basically said, well, the school district and the city got out on the summary judgment, basically said they had immunity for this accident because it occurred on the other side of the street from the bus stop.
I don't understand that. Why is that?
Well, he just said it was too far, the causal relationship. If it had happened at the bus stop, they would have been, but this happened on the other side of the street as she's crossing to get to the bus stop. So
Tell me about your private life. What do you do for fun?
So I was a baseball player in college, and I still enjoy coaching kids in baseball. I was a right-handed pitcher at the University of Washington, and big year for the Seahawks up in Seattle, of course. But I still give lessons for pitching for free. I have the dads come out with me. I show them the proper throwing mechanics for 8, 9, 10, 11-year-olds. I just love that. And that I can show the dad, this is what you do. This is the proper throwing mechanics. And, the dads pick it up. And I can't be there for their games and whatnot, but they pick it
Try
up.
to keep those kids from getting bad arms. Huh?
That's it. No, lay off the curveballs and learn how to throw a 2 and 4-seam fastball, and then maybe a little circle change.
All right. So listen, everybody, this has been a great edition of This Week in Law with Geoff Wells. I really thank him for coming. I thank you for watching. I ask you to like the show wherever you watch it and watch for the next edition.